Welcome everybody. For those who don't know me, I'm Laura Skillen, the Executive Director of the International Mediation Institute, and I have with me as well Marcus Lim, the CEO from our friends at SIMI. So hi to Marcus.
Hi everyone, thanks for coming.
Now for those of you who haven't used Zoom webinar before with the Q&A function, just a little bit of house admin. If you have questions during the presentation from our wonderful speakers, who I'll introduce in a moment, please submit them via the Q&A section you'll see at the bottom of your screen or on your phone. The format for today will be some presentations followed by the Q&A section. So all of your questions will be addressed then. But with no further ado, we have both Kelly and Elena with us today. Now, Kelly is a member of IMI's Young Mediators Initiative, and you might have already seen her article a couple of months ago about the new mediation law in Greece. And Eleanor, of course, is, I think, one of our task forces, as well as IMI certified and associated with a qualifying assessment program. So very happy to have both of you with us here today.
Thank you, Laura. Thank you for the invitation for today. It's a great honor to have this presentation with Elena. She's very popular, not only in Greece, but in general. She's a mediation guru, let's say. I don't know if Elena wants, do you want to tell something? Or we will proceed with the presentations.
Well, I need to follow up on your comment on the guru stuff, which is quite an exaggeration, but thank you so much. It's a pleasure. I want to congratulate IMI for hosting these very interesting webinars with a variety of speakers. Having Kelly next to me is a wonderful opportunity to share like an old insight and a new, fresh insight into mediation. We will do our best to accommodate your questions. We have decided to combine our presentations with Singapore Convention and Greece latest reform on mediation, and we will be happy to receive questions after our presentation. So thank you very much, Laura, for having us, SIMI for supporting this event and co-organizing with IMI. It's been a pleasure to be here.
As mentioned, today we will talk about the Singapore Convention on Mediation and how it affects Greece. I will begin with a short overview of the convention, as I don't know if all the attendees, I'm sure that there are many mediators among us, but there are definitely other professionals that support mediation worldwide as an alternative dispute resolution procedure. So I will share my screen with you. I'm sure that we are all familiar with mediation in general. The advantage is that it is a cost-effective procedure, time-saving procedure. It grants parties a substantive degree of control over the outcome of the dispute, since the settlement terms are crafted by the parties. It has a commercial attractiveness, but not all businesses utilize the advantages of mediation. They remain skeptical. And this issue tries to address the Singapore Convention on Mediation. There are many professionals that have the question, what is the point of mediation if any settlement reached is not binding in the sense that it is enforceable? And this is often said in relation to the domestic legal framework, but it has also increasingly been the case in respect of cross-border disputes. We live in a globalized world now, and it's gaining greater significance. The Singapore Convention, as I also mentioned in this slide, it's a promising start, but has definitely an uncertain future. It is an international agreement on recognition of mediated settlement agreements. It's definitely in its early infancy. It is yet to be seen whether it will be widely adopted in practice, but the signs are definitely encouraging. It was adopted on December 20th, 2018. So far, it is signed by 52 countries. On this map, we can see in yellow the countries that have the signatory states of the convention. The ratification, it's something different. The convention was open for signature by all states on the 7th of August 2019. The convention clearly states that at least 3 signatory parties would have to ratify the convention in order for it to enter into force. And the signatory parties so far that ratified are Singapore, Qatar, and Fiji. Qatar is the last one. So in about a month and a half ago, so in 6 months, on September, the convention will enter into force. The issues that the convention is trying to address have mostly to do with enforcement. So in the absence of a cross-border framework for enforcement of mediated settlement agreements, the aggrieved party so far is required to enforce the rights in a particular jurisdiction where the parties have agreed to litigate matters arising from the settlement agreement, and then take steps in another jurisdiction to enforce against assets to satisfy any judgment or award. And that definitely is a lengthy and costly process, and the convention tries to ease these problems. It eases the enforcement. It allows the enforcing party to direct enforce the settlement agreement in the courts or by any other competent authority. And it expedites the procedure of enforcement of the agreement out of the assets belonging to the non-compliant party located in another contracting state. So the convention, as mentioned, applies to cross-border commercial disputes resolved through mediation. At least 2 parties to the written settlement agreement, that's a condition, have their places of business in different states. The convention excludes from its scope, though, agreements related to consumer, family, inheritance, and employment matters. But it has some stages of this direct enforcement. The party relying on the mediated settlement agreement should furnish the competent authority of a contracting state with a signed settlement agreement and with evidence that the agreement was the result of international mediation, and then the competent authority must enforce the settlement in accordance with its rules of procedure. Of course, the convention introduces some grounds to refuse the enforcement. I will not further elaborate on this, but it definitely has left it to the contracting states to determine the exact mode of enforcement in accordance to their own rules of procedure. The convention definitely introduces some concerns. All new things have introduced concerns and uncertainties. Many domestic legal systems are still unfamiliar with mediation. And as a result, if the determination of a particular model of enforcement of a mediated settlement agreement were left to the contracting states, it would lead to a great deal of uncertainty with respect to an effective application of the convention in all jurisdictions. There is an absence of a clear mechanism that would cause definitely practical difficulties. And more broadly, the mediation as an alternative dispute settlement mechanism is not recognized in the domestic legal systems. For instance, Iran is one of the first 46 signatories of the convention, where mediation, though, has not been recognized in Iran as a mechanism for settlement of disputes in its own legal system. So, given the novelty of mediation as a dispute settlement mechanism in certain jurisdictions, the competent authority will definitely face difficulties in the proper enforcement. That is definitely something that concern us. And in the absence of this appropriate domestic framework, the competent authority many times will have no choice but to proceed with the case as a normal breach of contract, for instance, and to apply applicable remedies. And this is indeed not in conformity with the obligation of member states regarding the direct enforcement of cross-border settlement agreements. The European Union and the UK now are not currently signatories to the convention. There are definitely, the EU is considering whether we will sign as a union the convention, or whether its member state will sign the convention individually. That is something in the future, placed in the future though, that's for sure, because currently the EU has a framework on cross-border mediation. It's the Directive 52 of 2008 of the European Parliament, and it has to do with aspects of mediation in civil and commercial matters, but the directive does not envisage direct enforceability. It states generally that the content of a written agreement resulting from mediation could be made enforceable by the parties. So in most of the EU countries, the homologation of the settlement agreement by public authority, commonly notaries and judges, is necessary. And this definitely may result in the settlement being embodied in an instrument, for instance, a judgment or a decision, which in turn can be subject to the applicable existing EU regulations on intra-EU recognition and enforcement. That is definitely something to be taken under consideration, for sure. So after this short, I hope, introduction, I think that now, Elena, the floor is yours. Greece is not one of the signatory countries of the convention, but we definitely have a future. So, Elena, please, the floor is yours.
Okay, thank you so much, Kelly, for the introduction. So, as I said in the beginning of our presence here, what we wanted to share with this group of participants and with IMI is to give an insight of the Singapore Convention. Again, take this opportunity to introduce the latest reforms that we've been having in Greece, and the new law that's been kind of constantly being on hold because we are awaiting for its full implementation to come into place for a long time now, and it goes back. It has a long history, which I will try to give you some understanding in the next couple of minutes. As Kelly has mentioned, Greece, as a member of the European Union, has been also a country that introduced mediation following the introduction of the EU directive back in 2008. So from 2010, we had a law on mediation in when we implemented the directive into our internal legal system, a law that remained in force for 7 years. A couple of things went well, but a couple of things were obviously in need to be done better. What went well is that we had a law on mediation, which we didn't have before, a law that provided for a code of conduct for mediators, but also a law that inspired an obligation to inform clients on mediation to be introduced in the code of conduct of lawyers, training institutes that kind of brought to the market almost 2,000 mediators in 7 years, a body that accredited mediators sitting and entrusted with the supervision of the mediation practice sitting at the Ministry of Justice, numerous events, conferences, and a wonderful website, which is actually now in force, also that gives information about mediation in Greece. But talking with numbers, unfortunately, and based on the EU Justice Scoreboard, Greece still ranks among the last in efficiency in justice. We unfortunately are a country that counts an average of 1,580 days for a case to be resolved in court. A huge backlog in the cases still not heard in the courts of first instance and courts of appeal. Thousands of cases being lined up every year in our relevant courses. And unfortunately, due to those statistics, that the number of cases settled through mediation were disappointingly very low, which definitely did not reach the challenge that was that was set by the EU directive to achieve a balanced relationship between the out-of-court procedure of settlement of disputes and the judicial settlement of disputes. So the challenge was clearly not met, and the need to things to be done a little bit better came up at the end of 2016, where the issue of mandatory mediation came to the forefront. And by the early January 2018, we had a new law, a law that took the brave step to introduce sort of a mandatory requirement in several types of dispute, but a law that was later on attracted by a lot of criticism, criticism that was focused on the types of cases, on the costs affiliated and associated with this participation in the mandatory mediation process, and a fierce reaction by lawyers and judges that focusing both on the way the law was introduced and on the substance of this law. This led inevitably to the Superior Court stepping in and publishing an opinion by the judges with a narrow majority of 21 versus 17. The law, that form of the law back in 2018 was suggested to have issues regarding its constitutionality and the violation of free access to justice. Basically, the criticism focused on the costs associated to the process, and that led to the suspension of the application of the law for another year. That also led to working groups being set up by the Ministry of Justice, and finally us having a new reality, a new law endorsed by the Greek Parliament in November 13th, that was late last year, that introduced, reframed the requirements for mandatory mediation first meetings, and at the same time setting new dates for the application of the new law in 2020. New dates were set for January 15 for all family disputes, actually for most of the family disputes. And the next date that was going to signpost the beginning of a workload for mediation was set for March 15th. And that would include all disputes above 20,000 euros that are falling within the scope of what we call into our national law, the normal proceedings, to be fall into the scope of what we call the mandatory mediation first meeting. For those of you who don't know exactly what happened with Greece in terms of the coronavirus challenge, that was March 15 was never a date that this came into force due to the shutdown and the lockdown that was imposed by the government in an effort to control the spread out of coronavirus in our country. I need just to make a slight intervention regarding one of my PowerPoints. Said there was a typo there. It's disputes over 30,000 euros, not 20, as it's wrongly typed there. So excuse me for that. In a few words, what does this model of mandatory mediation include? It includes, other than away from the obligation of the lawyers to inform the clients in writing that was already there, notification by the parties of how to get into this mediation first meeting, obligation to attend in person, except for cases for when this is not possible, this meeting with a mediator who is appointed by a list, through a list, which is held with the Ministry of Justice, and some deadlines that need to be abided to in order for this first meeting to take place. There is an obligation provided by the law for parties to be assisted by lawyers, with the exception of small claims and consumer disputes. What does mandatory mediation means in practice is that for the party wishing to file a case in a court, should this obligation by the law is not followed, then the consequence would be inadmissibility of the hearing of the case. For the party summoned but not appearing, defendant or even the claimant, that non-appearance would probably lead to a fine, because it's in the court's discretion, ranging from 100 euros to 500 euros, based on an assessment of the reasons of non-attendance. The new law introduced further reforms, namely the new code of conduct for mediators, a mediator's fee for this first meeting that is set for 50 euros unless otherwise agreed. New training conditions for the accreditation of mediators. We have a minimum of 80 hours. The setting up of what we have as a main body to supervise mediation, which is the Central Mediation Committee. Rules on enforceability of the settlement, of the settlement agreements, and according to the Greek law, this can be done following what the EU directive has said and following up on what Kelly has just mentioned about the Singapore Convention. Our way of making an agreement enforceable is by filing this with a competent authority that would, with the competent court, that the case would have been heard. We also have a list of public registry of mediators to the website that I indicated before, and a huge effort to keep good track of statistics to see how this law is going to be enforced. Of course, there are many challenges regarding the implementation. First and foremost, how much the stakeholders would endorse this process. If the models of mediation that have been endorsed by the Greek law are efficient enough, if there's if the adaptation to the local needs and the existing law and the civil procedural code of Greece would adjust to the new reality, what would mean that in terms of the costs the party would incur by choosing this method. There is also the question of the quality of the mediation services, of the mediators, their training, their supervision. As I mentioned before, good keeping of statistics is going to be very crucial to see how efficient this model is. And of course, again, we need a peaceful coexistence with dispute resolution processes that involve also the courts, because quoting what the High Court judge said in the opinion that I mentioned earlier, mediation is neither a panacea nor an anathema. And adding a few extra challenges that we have been faced as, because as I told you in the beginning, the law is still on hold. The new challenges that this coronavirus era has posed on everybody is how efficient mediators and the parties are in making the best use of all available tools and platforms to conduct mediations online. So it means it requires a great deal of how comfortable professionals can become and get familiarized with the new digital world, and be fully aware of the pros and cons of the use of technology in dispute resolution, which involves, among others, how to handle times, how to prepare, how to use all the documentation that is now provided by law and could lead to inadmissibility of cases in the court if not conducted properly. The amount of flexibility that is related to using technology as a fourth party in this mediation process, issues of communication and engagements of parties, and of course, legal issues regarding confidentiality. As I said in my beginning, and this is the last for me, we do have another law that we are eager to see how it will be actually put in practice. We are again once more on hold, but we are still holding on there. We're very optimistic this is going to work, and we are also very optimistic that this will enhance the use of mediators by the wider public in Greece and worldwide. So thank you very much for your attention. I will now stop sharing my slide presentation, and I will be back to you for questions.
Perfect. Thank you so much to both of you for those incredibly interesting and I think timely presentations. I know that I learned a lot, so that was fantastic. Before we turn to the Q&A, I'm just going to be a little bit cheeky and throw in my own question, because it sounds like there's a lot of fantastic developments with mediation in Greece, whether they're, you know, coming out slowly or not. But you did mention this really interesting perception issue where litigation is the only way to resolve a dispute. I mean, is there anything that can be done specific to Greece, do you think, that can actually help to change that dynamic so mediation is taken as a serious way to resolve disputes?
Well, yes. I think that we've been trying hard for many years, actually since the end of 2016, to change this dynamic. Because the soft way of introducing mediation, which is on a fully voluntary basis, has not produced the results that we were aiming at. I'm not sure if I should advocate for mandatory mediation worldwide, because it definitely depends on the jurisdiction and the mentality of the people and everywhere. But in countries where mediation is not widely used, I am one of the persons who fought for the introduction of this new way of enhancing and promoting the use of mediation in my country. And I strongly believe that with sound legal frameworks at the EU level and on an international level that provide for a secure space for people to mediate and give incentives for people to mediate, like the mandatory first meeting, the easy way out, attending a first meeting is the only option if we want to see this means of dispute resolution process being widely used.
And to add on this, I think that also the legal professionals have a key role to play in this direction. I think that mediation first the legal professionals need to introduce it also to their clients to support mediation as an alternative dispute resolution.
Fantastic, thank you. All right, so I've got a few questions now submitted via the Q&A. If you'd like to go ahead. Oh, people are adding more in as I look at it.
So Ivana Ninchits asking, do lawyers need to represent clients in both mediation and in court proceedings, or is it an obligation only in mediation cases, except for small claims and consumer? Lawyers have to represent clients in court as well, with the exception of few cases. So it goes both ways. Mediation and court proceedings are similar in this respect. And she goes on and asks, how is enforceability of a settlement agreement achieved under the current law? What are the lawyers' reactions to the new mandatory information session model? You want to say, Kelly, about the enforceability?
Well, yes. So far, with the new law, the enforceability, both of the parties or the mediator has the opportunity to enforce in front of an authority, a competent authority in courts, the settlement agreement of mediation, and then it can be enforced. That's the current framework in Greece. That's the model now.
And the huge question about what is the lawyers. So a huge question about how was the lawyer's reaction to this new model. Well, as I mentioned, well, the facts speak for themselves. So the lawyers took the initiative to ask for the Supreme Court to issue an opinion on the constitutionality, which ended up with further suspension of the law. It's an understandable reaction to something completely new into the Greek legal system. I think lawyers are becoming more and more positive to the idea of trying this. Of course, there are several reservations about how efficient the whole model would be, and if it would actually lead to the increase of cases, of relieving the overload of the cases from the courts. This is what we are looking at ourselves. So fully understandable how they react. And I don't know if Kelly wants to add on this.
No, I totally agree with you, Elena. I hear that many lawyers are positive now to mediation. Also from how they can proceed with certain disputes, a lot of time and costs for their clients. That's for sure. I'm getting another question from James. Do you have private mediations in Greece? How it is regulated, or is it court mandated only? Well, I think that most of mediations in Greece are private. They are not court mandated at the moment. The parties, according to the law, the parties are have to attend the first meeting to try and see if they can resolve their dispute through mediation. And if they are not able to do so, then they will go in front of the court.
To build on what Kelly has just said, we don't have in our law the possibility for a judge to order mediation. So the judge can only invite parties to consider mediation, and it is upon their free will, their acceptance of this invitation by the judge. Unfortunately, a survey that had been recently conducted by the Association of Greek Mediators revealed that there's so much use of this discretion by the courts to invite parties. So it's really very disappointing that we don't have too many judges inviting parties to attend a mediation for the resolution of their dispute. I have a question here from Ivana Ninchit. Please forgive me if I don't pronounce names correctly. Is that something that when will the new law become applicable? The new law is applicable, by the way. The only thing that remains to be on hold is the application of the required mandatory first meeting for all cases falling within the scope of normal proceedings that exceed the value of 30,000 euros, as I mentioned before. We are on hold based, I mean, all limitations and are suspended due to the coronavirus. So we are soon expecting to be able to host our first mediations that are related to this law. Alexova, hello, Rosa. Great to see you here. Personal expectations in the long term after COVID-19. Great. Huge. Huge expectations, because this is actually what we were hoping for, to give a boost to the mediations conducted in Greece. But at the same time, lots of concerns in terms of the implementation. What I can say for sure is that the Ministry of Justice is working very, very hard and is listening to all stakeholders involved in the most efficient implementation of the law. So this is a very, very good and positive sign that we are there, we're getting there. If changes need to be made, they will be made in order to incorporate the new, this new process into the Civil Procedural Code, which has been in place for years, and we don't want to disrupt in any way the way the whole judicial system in Greece have been working so far. So we have very positive signs from all stakeholders to be committed to a good implementation of the law.
I think that following Kin Hauteo question, are there any particular reasons why the numbers of settled mediation cases are so low? Well, actually, so far before the mandatory mediation, the first session was introduced, even the mediation cases were very low, and I think we elaborated on this also in Elena's presentation. She mentioned that even the legal professionals weren't familiar with mediation, so it's not a procedure that someone would choose to follow to resolve their client's dispute. So that's why the settled mediation cases are also low, because even the clients that weren't familiar with mediation, when they attended the meetings to begin with the procedure, they were very cautious, and they didn't know if they should try this procedure, try to resolve their dispute. They thought that maybe if they would talk about openly with a mediator about their problems, that would also cause further, if they would go in front of the court, problems with the other party. That's definitely something to be taken under consideration. But let's hope that now that we have the mandatory mediation, something will change in a better direction.
Next question comes from Mark Go. What is the difference in enforcement that is between the traditional method of suing under breach of contract versus enforcement under mediated settlement agreement? So basically, when we have a mediated settlement agreement, what the Greek law provides is that you can, any of the interest parties can take these settled agreement and file it with the competent court, with the registry of the competent court. It's a stamp process. The judge does not get into examining the substance of what is settled in this settlement agreement. So by the time it gets it's rubber stamped, and you only need to to file it with a €50 extra burden, it becomes an enforceable title, which means it's almost tantamount to a court decision. When you have a breach of contract, obviously you need to sue somebody, you need to have your case heard in the court, and you need to wait for the final decision to make it enforceable. On top of these, there is also another extra cost related to when you want to execute a decision, when you have a court decision, which this cost is, you are relieved of this cost when you want to have it enforced through a mediated settlement agreement. I believe personally that the Greek legislator proved that he very much wanted to enhance the use of mediation by the parties and accentuate the benefit of having a mediated settlement agreement even at the enforcement level, because not only it's immediate, it's also less costly to execute it should things go wrong, which we hope we won't. I hope I've answered that question. Yes, Kelly, you want to take Evgenia?
Yes, Evgenia, hi. So you're asking if we have any information on what will happen with Greece regarding the signature. Well, as I mentioned also in my presentation, we don't know. We don't know what will the EU do, because they are considering signing the convention as a union, or if every single member state will sign the convention individually. But it's definitely something that it's not a priority at the moment, and for the EU and for Greece. We don't know what will happen in the future.
So yes, there are no signs. I think the EU is a little bit delaying in giving us a clear picture whether member states should move on separately, or if the EU, and it has the power to sign it as a union. So we are waiting to see the reaction. I think it's not a secret that there are different voices in EU about the Singapore Convention. But the fact that it is there, it's a huge asset. And personally, I think it needs to be promoted as much as possible. I have a follow-up question by Mark about the mediated settlement agreement, and a very good one, actually. What if the drafting of the mediated agreement is poor? This is a very good question. It remains to be seen. Of course, we need to identify what you mean by poor. If it's not, if it's legally poor, that means if it has some legal defects, that's a huge issue. But according to the Greek law, as I already mentioned, the judge has limited authority in looking into the substance of the mediated agreement. So it remains to be seen whether there will be objections raised by either parties, what are the deficiencies in this agreement, if there are deficiencies that link to what we call the type, the way it was drafted, if the persons needed there, if the signatures are correct, or if it's about having an agreement that contradicts legal rules in its substance. It's something, it is to be seen. It's one of the legal issues that have arisen and gave room for lots of discussion. Of course, we haven't had an experience so far with enforceability of mediated settlement agreements, and we're all looking forward to understanding what's behind that and what extra issues might be raised in there.
Sorry, I didn't cut you off because I know Marcus has a question.
Yeah.
I'm quite interested to hear your answer.
Yes, actually, I thought of another question too, but I'll ask the one that I was discussing with Laura. So, Elena and Kelly, you know, you're working so closely on the ground in Greece in mediation. I just want to ask you, hypothetically, and I'm saying hypothetically so that we don't reveal any identities, right? Hypothetically speaking, if a lawyer tells you that I don't want to do mediation because I can't earn money from it, what would you say in response?
Elena, do you want to answer first?
Yeah, I've answered this
name.
question. I've answered this question so many times. Well, what we have failed, unfortunately, in convincing the lawyers in this respect is that they have money to earn. This is a process that requires the full engagement and the active participation of a lawyer. And all those lawyers that I had the privilege of having them trusted me in conducting a mediation, soon after that said, there is money into it. We just didn't know it was there. Because if you have a client which is satisfied, on top of what you would have had as your legal fee, as your contractual fee for representing him at court, you get a top up on this sometimes. The client is so relieved to have his case settled in a day or soon afterwards that is very much willing to accept even a contingency fee on success for a lawyer. So lawyers are not aware of the benefits they can have in resolving a case for the clients. I think what we're failing, I'm speaking as a lawyer now, what we're failing to see there is that we are entrusted with the resolution of a person's problem, not with the litigation, with resolving it in a one-way street through litigation. So you can have a client satisfied if you have his problem resolved, whichever way is more appropriate, and always have a fee connected to it.
Exactly.
So that's all I'm saying. Just try it.
I totally agree with Elena. I mean, I have a personal example also from a client that at the end of a mediation, in one that happened, that took place in one day, he couldn't actually believe at the end that his problem was solved. His dispute was settled in just a few hours, that he didn't have to follow litigation, which frankly would be quite costly too.
So Mark, this question about international mediation and suggesting that it might be good to have foreign lawyer experts to set criterion. I'm not sure what criterion means in this question, like to share their experience in how these things are done. Is that the question? I think we have a wonderful and very skillful set of mediation advocates in Greece who just need an opportunity to experience how it is to represent a client in mediation. Of course, we could all benefit from the experience from international experts, international lawyers who have tried mediation, have seen how well it worked with their clients. But I have so much confidence in the skills of Greek lawyers to endorse the process and understand the benefits that they can both them and their clients can have in participating in this. Yes, to follow up on you, to make sure that the mediated settlement is valid legally in foreign country, absolutely. Absolutely. Any exchange of expertise and experience and enforceability would be of a great asset to make sure that the clients are fully protected should they need enforcement in a foreign country. Yes, that would be an invaluable assistance from international experts in this field. Following up, I have Pelagia. Hi, Pelagia. She says, if I could offer a bit to Mark's question, it is going to be considered as an issue of the execution process and in the competent court, therefore. Yes, I think, yes, I think we much covered this also.
Yes.
Yeah, so Laura, I know you have a question. Do you mind if I just ask a quick one? And this is going to be relevant for both of our organizations.
Go for it.
Okay, so Kelly and Elena, I know both of you are practicing mediators, and you know that between Laura and myself, we both run accreditation organizations for mediators. So if you could have a wish list, just one wish, not too many, just one, not 3 wishes, just one. What do you think that organizations like SIMI and IMI could do more for mediators that you think will help you in your work, right? Just anything at all, just be as creative as you like. Obviously, we're not promising anything and I'm not obliging Laura to anything, but we're just very curious to hear from you now that we have both of you with us tonight. Is there anything, any wish that you think that organizations like SIMI and IMI can do for mediators?
For my part, I know Laura and I'm familiar with IMI a lot, now with SIMI. And I think they are doing so far quite a lot. It's very important that they are trying to create a network of mediators worldwide, for instance, to share their insights regarding mediation. It's very helpful too that I am a young mediator, I'm in the Young Mediators Initiative, and it's very important that there are mentors there for young mediators to talk about issues that they are facing at the early stages of their mediator career, let's say. And workshops are very important too. And in general, every initiative that introduces mediation to the wider public, that it's very important for sure.
I've got my notepad.
So, yeah.
Thank you, Kelly. You being young was never in doubt. Same with Elena.
So Marcus, this is a tricky thing to say because wish can only refer to the future. And what you're actually doing now is live up to the expectations of everybody who needs support. So if I can link this to the future, I would say keep on doing that. It's really important to stay connected. Try to include as many people as possible, people who have not yet had the opportunity to understand how important it is sharing knowledge and experience. You're in Singapore, we're in Greece, see how We completely erased the distance. We've met several times in the past. We keep on meeting in e-environments and in physical spaces as well. So wish for the future. Let's all work on that as much as we can. Stay connected, keep healthy, of course, and dream of how to make this more efficient.
Okay, thank you. Thank you both. Laura, over to you.
Yeah, well, I think after that question, Marcus is never allowed to make fun of me for asking beauty pageant style questions ever again. But with that said, thinking then about the future you just referred to, I mean, what would each of you like to see? So it's 10 years in the future from now. What do you hope Greece will look like via the mediation at that time?
Well, 10 years is a long time, but it's a good question. I would have hoped to see the balanced relationship. I really believe this is a very strong word and a very, very ambitious goal. When we talk about the balanced relationship between judicial proceeding and out-of-court proceedings, we need to understand what's this balance we're looking at. Do we see 1%? Or do we aim to see 50%? So I would hope to see a huge increase of the cases settled through mediation that will be over 50%. That's the 10 years goal from now.
I totally agree with you, Elena.
I like that you've even framed it as a SMART goal. You know, it's specific, it's measurable, it's achievable, relevant. I think, yeah, it's a good roadmap, fantastic roadmap. All right, well, thank you so much to both of you for joining us for this incredibly interesting and informative session today. I mean, I know we've also had a lot of people on Facebook watching and loving it as well. So thank you again. And I hope that you'll join us for future editions of this series.
Thank you so much. Keep on the good work. Thank you. Thank you for having us.
Thank you both. Thank you.
Thank you. Thank you, everyone.
All right. Bye, everyone. Thank you for your questions.
Bye.